everybody. Dave Rock here, President and CEO of ProTech Building Services, and welcome to the Maintenance Manager. Fortunately, today we're here with Rachel Miller from the Miller Law Firm. And Rachel, you service all of California.
That's right.
And you're headquartered in San Francisco?
San Francisco and Los Angeles.
San Francisco
Yes.
and LA. Cool.
Yes.
You want to tell us a little bit about the Miller Law Firm?
Yes. Well, thank you so much for having me today, Dave, and everyone
You
at
bet.
ProTech. It's such an incredible honor to be here. It's so fun to think back about the history of the Miller Law Firm, and we have been representing associations with construction defects alone. That's all we practice for over 40 years. And it was founded by my partner and my dad. So we're a legacy company, which is very exciting. In 1981, after he represented builders and insurance companies, he even sat on the board of the BIA. So had saw the need to represent associations, and one of our very dear friends in the industry, Nora Jasky, actually asked him to consider representing HOAs, and that's kind of how he was introduced to the HOA world, late 70s, early 80s, and it's just incredible.
Isn't it a small world? Because
It's such a small
I
world.
worked with Nora.
Yes.
Starting in 1991, and I met Tom back then, and Nora was the one that gave me the idea for the maintenance manual.
Oh my gosh.
So that's where it came about, because essentially, a lot of times not doing the maintenance would precipitate a lot of problems.
Absolutely.
And so
I mean, those manuals, they're important. It gives the HOAs a roadmap of what they need to look at, and it helps educate them. So
Yep.
that is a small world. Well, we were based in San Diego back then.
I know, I remember.
Until the mid-90s. So,
And now you're working on all kinds of really cool projects, some high-rise projects. You had worked on Millennium Tower.
We did. We represented the Millennium Association for a few months. That's one of those most incredible stories, just like what's going on in the industry. We have quite a lot of high rises here in downtown LA, San Francisco, but all over the state.
Right.
We were in numerous states, about 20 years ago. So we have touched and educated the markets in about 5 states.
So you do work outside of California?
Now we do not.
Okay.
We have plenty of colleagues who do. So, but the need is nationwide.
Yep. And for those of you that don't know, the Millennium Tower is I think it's a 40-story tower in San Francisco, and it's the one that's a little off kilter, and it's been in 60 Minutes a few times.
It's been in 60 Minutes. It's sinking. It was sinking and tilting, so it's quite an incredible story. I think the other thing that we're most well known for is we wrote the book. We wrote the book on construction defects. Tom wrote the first book in 1986, so 30 plus years. He really put it on the map nationwide. We're in our 4th edition of the book, and we have 2 versions of the book, but when people refer to our firm, we wrote the book on construction defects. So there's a legal treatise, and judges and attorneys and mediators all over the United States rely on it. We update it every year, and then we wrote a consumer guide for board members. So we're really, really proud of that in its 3rd edition, and we partnered with CAI to help edit and have their perspective on our recent edition. So very exciting.
Yep. And it's quite a brand. The book has really helped your brand.
It has. It's always been about educating, as you know, as you do, and it's what you're doing today. It's always been about educating our industry and making it better and giving resources and tools to board members and community managers to help them. Especially with community managers, it gives them the tools to help them communicate with their own clients, right? So.
But I just want to make sure you don't just work on high rises. You work on any type of condominium community, correct?
Yes. So condominium associations, where we see construction defects in condominium associations is, as you know, they have to be completed within 10 years. So we can talk about that.
Gotcha. Excellent. So let's turn our attention now to, if you could, SB 800. So SB 800 was passed in 2003, the Right to Repair Law, and that's California's version, SB 800. Of course, there's right to repair laws in 47 or so other states.
Yes.
All different.
Yes.
All different flavors. And but I'd like to talk about SB 800 because I know you were active on it and I was active on it, helping the building industry,
Right.
define what what a defect was. So tell me a little bit about your participation in SB 800 and.
Sure. So we're talking about the task force that
Mhm.
the building industry developed, and then the consumer or trial lawyers or plaintiff HOA
Mhm.
lawyers developed. And we all, at a certain point, came together and helped identify 150 definitions of what a construction defect is.
Mhm.
And I think that was helpful for both sides.
Mhm.
It started out as this concept of we want to get rid of costly litigation, and the builders wanted an opportunity to repair defects,
Mhm.
which in some cases is great if they want to really come in, help investigate what's wrong, and can target a specific problem at communities. We're all for it.
Mhm.
Ultimately, we know though that when you have a host of experts that come in and look at all of the building components, you typically end up in a formal notice claim. But SB 800 has been really good for the industry.
Mhm.
It invites boards into a conversation where they don't feel like they have to thrust litigation on their community. Mm-hmm. It gives them the opportunity to communicate back and forth with the developer through counsel, of course, and it provides a roadmap. I'm all for timelines and roadmaps, and if you do let your builder know that you have, roof leaks, let's say, then if you send them that letter, they have a duty to respond to you within 14 days. And that wasn't always the case. The feedback was generally like, oh, we've let our builder know we have issues, but we're not getting the response we need, right? And I think that's where the communication breaks down. We always tell community management companies, let the builder know if you have issues. Let them come out and take a look at it. Let them respond, right? And by the time we're brought in, that response layer is typically broken down. But there's no reason why you can't start off. And that's where SB 800 came in. So
yeah, it seems to be working okay, although I don't know if there's been many cases on some of the points to the law itself. At least I haven't heard of many cases on point.
It hasn't really been challenged in the courts,
yeah.
is what you're asking, yes. So, which is good. It's a very clear process. You put the builder on notice. They have to respond. They have a right to repair. In our cases, at least, a good 80%, maybe 90% of the builders don't provide an offer to repair because the issues are too voluminous and they have insurance.
Gotcha.
Right? So
is it the insurance?
Let
insurance handle it?
Kind of. I mean, it depends builder to builder, and some builders are now self-funding and they're self-insuring. So they'll all respond through counsel, and we all know what that response looks like, but it does sometimes come down to insurance. Okay,
and for HOAs that are going through the years and they don't know if they have any defects that aren't visible, of course that could be changed now with SB 326.
Yes.
But what advice do you have for boards that are worried about whether or not they have defects in their building?
So SB 326 is going to require you by year 9, actually by year 6 too if you're a newer project. So there's a 6 and a 9 to start looking at building components. So it'll give them that resource to say we had to spend the money and the resources to investigate at least all of these elevated exterior elements. That's the catchphrase. That'll identify that they do have issues. I think what you're asking is, let's say we're 4 years old and we know we have a lot of issues. Is it too early to go into a claim process? Because what happens if we identify something in 10 years that we didn't know about?
Right.
That's where insurance comes in. So we have to prove resulting property damage. We have to prove that something is failing, right? But that means we have to open everything up and look at every building component, because in the end, in any lawsuit or any claim you're ever in, the insurance company is gonna want a full and complete release of claims. It would be the same as if you had a claim against your MD or your car manufacturer, what have you. So we really do have to spend a lot of time with experts and identifying everything that could be possibly wrong with the association. So, but by the time we're done, we have a very good handle on what is wrong and how much we need to fix the issues.
Yeah. And 326 is interesting to me
Yes.
because, you know, we're not structural engineers or architects,
Right.
but we do tons of inspections.
Right.
And there's so many different things we inspect in addition to the decks.
Yes.
And it's just interesting to me to see whether boards are going to continue to inspect all the things that they need to inspect. I always say that all common area components need to be looked at least once a year. The example being the fencing, this big project that we worked on, I think it was 9 miles of metal fencing had not been looked at in 7 years. And it was a big mess.
Corroded.
So yeah, there were 400 sections, 8-foot sections that were just completely gone. Again, it was close to the coast and the wet air. But my point being is that wasn't a deck.
Right.
So you still have to inspect a lot of things in addition to the decks, but that's a sidebar.
I think it's important. I don't think community managers understand this is not just a deck inspection or a balcony inspection. And this happened because of what happened in Berkeley in 2015. So 13 kids were partying on a balcony at 1 in the morning, and the balcony snapped off the edge of the building. And so devastating. 6 of them passed away. The structural load of that balcony should have accommodated those 13 kids with the weights that they were. And so it just opened up this huge conversation, right? And it was an international story because the kids were exchange students from Ireland. When it happened, we got called right away from the Associated Press to help educate the press as to what might have gone on at that building, because it was built as a condo project, even though it's apartments.
Oh, it was?
It was originally permitted. So that was our opportunity to say, okay, associations are not apartments, right? So this is a different conversation, but had it been a condo, you know, ultimately what's going to happen with, you know, what happened with the families and all of that. So that was where 326, you know, stemmed from. Now we know we have to look at more than just balconies. It's a new catchphrase for me, EEE. Exterior elevated elements.
6 feet or greater.
6 feet or greater in a condo building, only condo associations that are 3 units or more.
Right.
So we have to look at walkways, stairways, railings. We have to look at anything that's 6 feet above the ground that's wood-based construction. And it's associated waterproofing systems. So you know, your mind's spinning right now. Just to get to the waterproofing systems, we have to open areas up and see how they're performing, right?
There's a lot there. No, and it's just so interesting though. The law it's got so many ramifications. I mean, you know, what we're seeing and hearing is that a lot of HOAs are bristling at the high cost of the inspections if they can find an inspector. Because the inspectors are a little busy, and there's been some companies doing inspections using engineer stamps. Now, that's a different situation, but anyhow, and I also have learned that they may make modifications to 326.
I'm sure they will over time to see what's working and what doesn't work. One of the modifications, the question is, are they going to start to include high-rise construction in 326? Are high-rise buildings going to be required to inspect their decks and balconies and elevated walkways? So because they're concrete and steel construction, it doesn't apply. SB 326 only applies to wood or wood-based products. And construction of that. But I think that might be a change that comes. And
could be. But that is a good segue to our next topic, which is, you know, the Champlain Towers collapse in Florida, which I'm sure you followed pretty closely.
Yeah, it's devastating.
Yeah.
It is. Were you able to go?
I haven't been on the site, no.
Okay, the site.
But I did write an article about it, so I researched it quite a bit and wrote an article for Common Ground on it, and was part of the task forces, the 3 task forces that CAI put together. They came up with laws or suggestions for laws, best practices for legislatures. That was in 21 last year.
Right, that's so important.
And those CAI gave those to all the legislatures, and some have
Yeah.
actually made new laws. Florida did, New
Okay.
Jersey did, a few other
Okay.
states made new laws, mostly incorporating, the structural inspections and also incorporating reserve studies, because there's only 7 states that
So
require
important.
reserve studies right now,
It's so important.
and 11 that require funding of reserve
Right.
studies. So we forget here in California that there's a lot of other states that don't have reserve studies, which
Yes,
is interesting.
I don't know how you would, even when you recover those several $1 million from a construction defect claim, you want to weave in your reserve and have that financial plan. It's a collaboration. So
Yep.
I can't imagine what HOAs in those states are doing
Right.
to fund.
And what I think we have to deal with here is, and we talked about a little earlier, is the board dysfunction. Because if you look at what happened at Surfside at Champlain Tower South, was that the board knew they had a problem, and they brought in contractors and consultants and a structural engineer. They identified the problem when it was a $3 million problem, but the board had that dysfunction where they didn't want to raise dues because they thought they'd be recalled, or because it raised so many hackles within the community, which is a common thing. Boards run into such problems raising assessments and doing jobs that they need to do. So $3 million problem turned into a $9 million problem, which turned into a $16 million or $19 million problem, and of course, we all know what happened.
Right.
So, do you want to talk about that board? I call it a board dysfunction there.
My first answer to any time somebody wants to talk about board challenges is please turn to council. You don't have to turn to a defect council, but there is a whole coterie of HOA specialists in this country that can help guide boards, help them identify their fiduciary duties. What does a business judgment will really mean? It's a tool for a board to be able to make a decision. If they make that difficult decision and they've relied on counsel and experts, but even if an owner challenges that, they're still protected, right? That's at least in California, and I'm sure there's variations of that. Yep. I'm certain in Florida. It's board training, counsel, experts, those experts that a board can rely on, I think is the key to their success. What happened in Champlain Towers was incredible. Nobody's ever seen anything like it. This wasn't a natural disaster. It reminded me of the Laguna Niguel landslide that happened in the 90s. That we could foresee because we were able to measure the slope movement in Laguna Niguel and get people out of their homes, which were ultimately, crushed.
Yeah,
so
I remember.
This was something, it's definitely weaved into with 326 here in California. Looking at these structural components, not just these elevated EEE.
Yeah, no,
but
it's really two separate things. You've got high rises, which have their own issues that have been exemplified by Champlain Towers, and then wooden structures. But I think the problem is with the high rises, it's even more of an insidious and dangerous problem. I don't know if you've heard, but there's 2 other more recent problems: the Renaissance Towers in South Carolina, which had to be evacuated, similar size structure to Champlain Towers, and then another high-rise 1.5 miles from Surfside, from the Champlain Towers collapse, had to be evacuated, a building called Port Royal.
Yes.
And same thing, structural problems with the metal structure.
Right.
So anyhow, there's a lot more to learn from these 2 instances, but my concern, I think CAI's concern, is that there's a lot of buildings that are having problems.
Right. Well, 2 things there. One, I think engineers and architects are going to start to go to the local municipalities. They've identified something that's a threat to the occupants of the buildings, right? So I think even with 326, I think that's how we're going to be able to enforce these requirements, because an engineer is going to have their license on the line, and if they turn in a structural report to the code enforcement agency, the building department, what have you, whatever you call it in that city, that's going to be a good layer to come in, and that agency will come in and then identify if we're going to red or yellow tag, that's what we call it here, buildings, evacuate occupants. But ultimately, this goes back to the funding, right?
Sure does, doesn't it?
You know, if you want to talk about boards that have challenges or dysfunctions, what have you, they're ultimately faced with how do they pay for these inspectors and how do they fund these massive repair programs?
Yeah, I mean, the inspections under 326, we've seen $30,000, $40,000, $50,000 to do just the inspections, let alone the actual subsequent repairs.
So 326, and there's another warning I would have to caution to the industry, and this has been brought to me by community management companies. There's a new layer of free deck inspection companies that exist now. We saw this with SB 800 too. Look, attorneys, particularly contingency attorneys, will go out with experts and do their own due diligence to see what the gravity and extent of defects are. But this concept of a free deck inspection is, I think it's going to bundle up the industry for a bit.
Yeah, I've heard about that actually. And those free deck inspections are only for associations 10 years or younger.
So you have seen this. So obviously,
I've heard about it.
Just for the purposes of the audience, because if you're under 10, you can pursue those claims against the builder. So if you're under 10, yes, you should engage counsel, do the inspection, and present it. One of your funding options is for the builder's insurance to pay for it in the general scheme of a claim notice. If you're over 10, you've got to look to regular financing options, which is your reserves, which you can start planning for now. We have 2 more years left before the deadline to just inspect occurs, which is January 1st of 2025. And then it's going to be very busy in the next 2 years.
Oh, yeah. Right? It's going to be quite a couple of years.
Right. That condition, that new market layer has been brought to our attention. So there's a way to do it.
That's an issue, but I think you've identified the key thing, which is the financing of all of this. The boards have to get guidance from hopefully our industry.
Council too.
And council especially. To learn how to raise assessments to pay for these things.
Yes, to have a financial assessment plan. Create your team, your council, your bank contact, your reserve analyst, and there's a whole host of other team members you could bring in, including experts and construction managers and inspectors. If you do go out and hire an inspector for this, well, let's just be clear. It's not just any inspector. You have to hire a licensed architect or structural engineer.
Exactly.
Very expensive process. But if you go out and hire one without the shield of counsel, that report is eventually what's called discoverable. It's not protected by the attorney-client privilege. So I implore community managers to please have corporate counsel, engage them, have them call the expert, and make sure that this is done under the guise and protection of counsel, which then when we go to communicate with the community, here's what it's going to cost to fix. Outside of the construction defect conversation, you've got layers of protection on the board.
That's great advice.
Right.
That's great advice. Actually, why don't we just end it there?
Okay.
And I want to thank you so much, Rachel, for sharing everything.
Thank you so much, Dave. I love seeing you, and it's so warming to be here, and it's an honor. Thank you.
Thank you very much. Thank you, everybody. Stay safe.